All right, everyone. Well, with that in mind, I am so excited today to be able to introduce Kara. Kara is an attorney with the California Civil Rights Department Outreach Unit, where she focuses on educating Californians about protections from housing discrimination and other rights. Before joining the California Civil Rights Department, Kara worked on state and federal housing policy and was a legal services attorney for over 10 years, representing tenants in unlawful detainers and civil rights impact litigation. So, we are so very grateful and excited to have her here with us today. We know that today's topic is one that many of our community members have expressed a lot of interest in. So we won't waste any more time. Please take it away.
All right, thanks so much. I appreciate you having me. Again, my name is Kara Birdfair. I work for the California Civil Rights Department. And when I get started, I always say this is my boring lawyer disclaimer. So just letting you know, we're giving you this information for informational purposes. We're not giving you legal advice. I'm very excited to answer your questions, but if I get the idea that they're about your specific situation or someone you know, I cannot answer them because that's considered legal advice. So just keep your questions general or, make up a little hypothetical. That will make it easier. And also just keep in mind that the law is always changing. And, I am going to be focusing mostly on California law, but there are most of the stuff I'm going to talk about also applies to the entire country. I will point out when it does not, but for the most part, most of this will apply to everybody. But with that, here is just our agenda. So I'm going to really quickly talk about what we do at CRD, and then I'm going to talk about assistance animals, which include both emotional support animals and service animals. And then we'll have time for questions. I also have a bunch of resources to pass along. So this is just a bit about what we do at the California Civil Rights Department. Our job is to protect people from discrimination in employment and in housing, from businesses. We also enforce laws against hate violence and human trafficking, and this is in California. And we do this in a variety of ways. I'm not going to go over them today, but essentially, we are the state agency that a lot of people file complaints with if you think you've been subject to unlawful discrimination in housing or employment in other areas that I talked about. And what we do is, if they involve the laws that we enforce, we investigate them. We try and get the parties together to come to a resolution, and we do a whole lot more. And if folks with disabilities need access to our services, they can get a reasonable accommodation, and this is how that can be requested. I believe this PowerPoint is going to get sent to you, so you don't need to write anything down right now. And the same goes for services in other languages. All right, so let's jump in. So federal and state housing laws. So I am first going to talk about the laws that kind of form the basis of the protections I'm going to talk about today. Also, that is my cat Hedwig on the right. It's fun to be able to use pictures of my own pets. But with that said, so we have federal laws. So these are laws that apply to the entire country. These include, as far as the protections we're going to talk about, the Fair Housing Act, and this protects people from discrimination in housing across the entire country. This includes protections for people with disabilities, which is going to form a lot of the protections we're going to talk about today. We also have the Americans with Disabilities Act. This requires businesses, including housing providers, and local and state governments, employers, public transit, and other entities to not discriminate and make these services available to people with disabilities. So those are the federal laws. And then we have California specific laws. We have the Fair Employment and Housing Act, which protects people from housing discrimination and harassment in California. And this includes for people with disabilities. And we have the Unruh Civil Rights Act, which protects people from discrimination by businesses, including housing providers. And in California, we also have the Disabled Persons Act, It's similar to the Americans with Disabilities Act. It gives people the same rights and full access to public places. And this is going to come into play a bit when we talk about service animals. And so, just briefly, we are getting a lot of questions right now because things are changing a bit on the federal level, and a lot of people are really confused, but I'm just wanted to let you guys know kind of how that works. So, basically, just think of it this way. So, federal law can sets protections. So, discrimination against people with disabilities is unlawful. And then states can actually have stronger protections, and then local counties and cities can have even stronger ones if they would like. So this is kind of how it plays out. So under federal law, these protected characteristics are protected from housing discrimination. This includes disability and religion, familial status, color, sex, race, national origin. And then California has additional protected characteristics, and I'm not going to read them out, but they're highlighted in red. So California has a lot more protections. But as far as the presentation we're doing today, most, if not most of the protections, unless I say otherwise, apply to everybody. So let's jump in. So we're going to talk about assistance animals. It's the main focus of this presentation. And what I mean by assistance animals are both emotional support animals and service animals. I made this graphic because I think it's helpful just to see kind of what laws and what protections apply. So we're going to start with emotional support animals. And for those protections, you're going to see protections from the Fair Housing Act, the Fair Employment and Housing Act, and the Unruh Civil Rights Act. And for service animals, we're going to see protections from the Americans with Disabilities Act and the Unruh Civil Rights Act. So this will make more sense, I promise. So we're going to start with a poll. So there's going to be a lot of opportunities for you to answer some questions. I think it just makes these presentations more dynamic and interesting and more fun for you. But here's our first question. So what is an emotional support animal? Is it any pet? Is it a trained animal that performs tasks to help someone with a disability? Is it an animal without training that provides emotional support to someone? What do you think? All right. We still have some answers trickling in, but we'll go ahead and end the poll. About 83% of you said an animal without specific training, and then 10% of you said an animal trained to do specific tasks, and 7% said any pet. And the answer is an animal without specific training that provides emotional support to a person with a disability. So let's talk about that. So the protections that apply to emotional support animals, they come from protections for reasonable accommodations. And across the country, people with disabilities are entitled to reasonable accommodations. An accommodation is essentially just a change in a rule or a policy that is related to housing to allow someone with a disability equal access to housing. And the protections we're going to talk about are going to mainly apply to specific types of accommodations, including exceptions to no pet policies. Because the accommodation you would be asking for, so say you live in a building and no pets are allowed, your exception you're asking for as a reasonable accommodation of your disability is going to be an exception to that no pet policy. And specifically, we talked a little bit more about emotional support animals. But, again, it's just an animal that provides emotional support to someone with a disability. Sometimes people call ESAs comfort animals or support animals. And it's just important to note that under the law, an ESA or emotional support animal is not a pet. And this is going to come up later. But basically, when you have an ESA, because they're not considered to be a pet, things that are required for pets, like paying an extra pet rent, for example, should not apply to an emotional support animal. An ESA is also not a service animal, and we're going to talk about what those are under the law, and you'll be able to see what the distinctions are. So, what are common stereotypes about ESAs? I hear these all the time. So, first one, my tenants are constantly lying that their pet is an emotional support animal to get around our no pets policy. So, I present a lot to housing providers, property managers about their obligations under the law, and I hear this all the time. So, this is a very common stereotype. We also hear things that, did you hear about the person who sued her landlord because she wouldn't let him have an emotional support horse in her apartment? I've never, in my whole time practicing, actually heard of a case like this. And we're going to talk a bit more about that. But, housing providers still can put reasonable rules on emotional support animals as far as space and health and safety and things like that. My cousin's friend was bitten by her neighbor's dog, but the landlord couldn't do anything about it because it was an emotional support animal. Again, we'll be addressing this, but that is also a very common stereotype. So let's just talk about, I think if because you're on this presentation, you might know some of these things, but I think it's just important to note that, emotional support animals are a very legitimate thing that a lot of people with disabilities utilize. There's been many recent studies. The studies that I'm talking about here found, when people have ESAs, they're actually experiencing things like decreases in depression, anxiety, and loneliness. Another study found that 2 in 5 pet owners surveyed had turned to emotional support animals because they couldn't afford therapy or mental health care. So again, we live in a country where not everybody has access to health insurance or insurance that would provide mental health care, and ESAs are an important tool to a lot of people. Um, Participants in that same study reported that support animals help them with anxiety, depression, loneliness, structure and routine, stress, trauma, sensory support, job loss, or economic uncertainty. So, again, emotional support animals, they're not just people trying to bring their pets, they are a very legitimate tool to help people manage the symptoms of their disabilities. All right, so the nuts and bolts. So, can housing providers prohibit a tenant or resident from having an emotional support animal? So, on one end, housing providers can definitely have rules about pets. They can have rules saying, no pets, certain types of pets. They can have rules to make sure that, pets aren't causing a nuisance or disturbing other people. But if a tenant or resident has a disability related need for an emotional support animal, and the housing provider must allow that person to have an ESA as a reasonable accommodation, unless they can show that an exception applies. And we'll jump into that. So this means that, if you can show a link between your disability and your need for an emotional support animal, a housing provider should make an exception to those policies. Does this mean that you can have an emotional support animal that barks and disturbs other people? No. Housing providers can still have reasonable rules. They can have rules around like what is actually feasible under a certain circumstance. I had a client who wanted 6 chickens in her apartment, and we all had to have a discussion about it because it just was not feasible. But say you lived in a house with a yard, then maybe that would be feasible. So we're really looking at each request on a case by case basis. There's no rule that says these types of animals in this size are allowed here and these types are never allowed. It's really different for each person in their specific circumstance. All right, so our next poll, true or false, documentation of the need for an emotional support animal must come from a licensed medical professional. All right, let's go ahead and end the poll. And we're 80% are saying true and 20% are saying false. And the answer is false. So I will say, and we'll talk about this, that California law is a lot more clear than the laws that apply to the entire country as far as this being the case. But federal law, there's also been a lot of guidance under federal law that, yeah, that documentation does not just have to come from a doctor or medical professional. It's an area that I think has confused a lot of people. Hold on, let me go back. The law basically says that anybody who's in a position to document the need for an emotional support animal, or a reasonable accommodation in general is enough to provide that documentation. And I'll say in my practice, as an attorney doing things in this area. Doctors are actually, especially when it comes to things like emotional support animals, are often not the best people to provide documentation because they're not seeing people on a regular basis in the way that like a therapist or a non-medical service provider would be seeing somebody. A therapist could probably talk way more about how your cat helps you manage the symptoms of your anxiety than a doctor would. Or any third party that's in that position. Maybe you have an in-home support worker. Maybe you have a friend or family member that helps you to do certain things that you're unable to do yourself. They're in a great position to provide that documentation. So no, it does not have to be from a licensed medical professional. All right, so let's move on. Can a housing provider request specific documents before permitting a tenant to have an emotional support animal? So, housing providers, when someone requests a reasonable accommodation, including an emotional support animal, housing providers can request documentation. And as we just learned, it does not have to be from a doctor or a licensed medical professional. So housing providers can ask for documentation, but only if the need is not obvious, or what the law calls readily apparent. And this means, if somebody is in a wheelchair and they're saying, hey, I need a reasonable accommodation to have a closer parking space, it's very obvious and clear why that is needed, and no more inquiry into somebody's disability related needs should be made. But for people who are requesting, usually for people requesting emotional support animals, it's not as obvious. But housing providers can't just ask for everything. They can't say, oh, I want to see all your medical records. I want to know what your diagnosis is. Tenants and people with disabilities, they don't have to disclose what their diagnosis is, what their disability is. They just have to get documentation that links their disability to their need for an emotional support animal. So, having your therapist write a note saying, my client experiences anxiety and difficulty getting out of the house, and having her cat with her helps her manage those symptoms. That is enough. It really should be very specific to that person and just enough information for the housing provider to be able to confirm that need. So, and this is just a bit more on, again, how it just has to be from a reliable third party, and the law is really going to look at things on a case by case basis. If you have just some random stranger, write a note to say that you need an emotional support animal, they might not have enough of a relationship. But, say you're a parent of a child with a disability, you are probably in the best position to talk about your child's individual need to have an emotional support animal because you're taking care of that child every day. All right, let's do another poll. This is about Hannah. So Hannah is applying for a vacancy with Carol, and Carol notifies that she notifies Carol she's going to bring an emotional support animal. Carol understands that ESAs aren't the same as pets, but she does want proof that Hannah's dog is a real emotional support animal. So Carol tells Hannah that she needs a certificate or a registration for her ESA before she can have it in the apartment. Can Carol do this? So I'm going to give you guys. All right, we have a lot of people participating. Um, but let's go ahead and end the poll. We have 62% of you saying no, 38% of you saying yes. The answer is no. Carol cannot ask for proof that this is a quote unquote real emotional support animal. So, question, does an ESA need to be registered to qualify for a reasonable accommodation? No. There actually is no legal requirement that an animal be registered or certified to be an emotional support animal. It's actually not a thing under the law. There's a lot of websites and businesses that say that they're going to give you a card or register your emotional support animal, give you a vest. And unfortunately, those websites are often selling you things that are actually unnecessary and are not required under the law. So no, there is no registry. You do not have to register your animal. So sorry, I was just looking at the questions. So just to note, but some of those websites do they sometimes will have somebody, spend an hour doing, a discussion with somebody to help establish their need and help them document their need for an ESA, and that could be legitimate. But things like these vests, all of the things on the right, it's not something that the law requires, and it's not something that is something that people need under the law. Okay, so let's talk about when a housing provider can deny a request for an emotional support animal that helps someone manage their disability. So if a tenant makes a request and they've shown, they have a disability related need, the housing provider should approve the request unless an exception applies. So one, if allowing the emotional support animal would cause an undue financial burden for the housing provider. That means that allowing it would be so expensive that it just would be like not possible. Usually this is not going to come up with an emotional support animal. Allowing someone to have an animal in their home is not going to probably cost the housing provider incredible cost. If you have an emotional support animal in your home, you cannot be asked to provide an additional deposit or pet rent. But say your ESA is a dog and they do a bunch of damage to the wall or things outside of normal wear and tear, you would still be responsible for that. So again, a housing provider can't say, well, that dog's going to destroy my unit and there's nothing I can do about it, because the tenant would still be responsible for that. So usually the cost is not going to come up. But when the second one, so permitting an emotional support animal would constitute what the law calls a fundamental alteration to the provider's business, this might come up more because sometimes if you ask your housing provider to let you do something that's really outside of what a normal landlord-tenant relationship would be, they can, deny that request. So this has come up, an example of this, which is less applicable here, but I think kind of gets the point across, is I had a client once who wanted me to ask her landlord to do her grocery shopping for her. And I had to explain that, landlords don't usually grocery shop for people. That's really outside of what a landlord-tenant relationship would be. And this can also come up when people are making requests for animals that normally would not be able to live indoors in an apartment. I will say this, take this with a grain of salt, but I hardly at all, if not ever, have seen cases where someone really wanted to have like a horse or, a large animal or, really inappropriate animals to live in an apartment. I've very rarely seen that. But that could be considered a fundamental alteration if you're like, hey, I want to have a bunch of barnyard animals in my apartment. But at the same time, everything is on a case by case basis. Say you have one emotional support chicken, for example, and it lives in a pen and you can keep it safe and it's not going to make a ton of noise, like that might be reasonable. So, a housing provider has to look at each thing individually. And the third way that this can come into play is if you having that emotional support animal would constitute a direct threat to the health or safety of people in the apartment complex or damage to the property. This could come up with animals that are inappropriate to be living indoors or at an apartment. Um, and if they're a direct threat and it can't be, mitigated by another accommodation, housing providers should not just be outright denying things. They need to put their heads together with the tenant and try and work something out. If that's not possible, then, it may be a justified denial. So, this is a question I get a lot. Can someone have more than one emotional support animal? And the answer is yes. If the need for multiple emotional support animals is not obvious, and usually it's probably not going to be, a housing provider can ask for documentation verifying the need for multiple animals. But the housing provider, again, can have specific rules to protect the health or safety of other folks and the property and what is feasible. They can consider what the total impact of multiple animals in the same unit amounts to, if it's going to cause a lot of damage, if it's just not feasible or healthy. They could put a cap on that, but it has to be done on an individual basis. They can't just be like only 3 emotional support animals per unit, because what if you had 3 fish? That wouldn't be a huge burden. So it really depends. All right. I already kind of gave this one away, but can a housing provider charge a fee? Um, Actually, I think we did not put this poll. Actually, yeah, let's put it up. Can a housing provider charge a fee for an ESA? I think I gave this one already. So I'm going to zoom through it. And the answer is no. So again, they're emotional support animals. They're not considered to be pets. They're considered to be, and it sounds strange, but like a medical device or, something that's helping somebody with a disability have more access to housing. So no. In addition, a housing provider cannot require someone with an ESA to obtain liability insurance. So sometimes people will ask to have an exception to no pets policy, and they'll say, yeah, but you need to get more renter's insurance. Or what if, your dog bites somebody, you need to get more liability insurance, and that is not allowed as well. But as I said before, an ESA that does damage beyond normal wear and tear would definitely, the owner of that animal would definitely be responsible to pay for that damage. So we can just do this one in the chat because I think we forgot to put that other poll in. But now that landlord Carol understands more about the law around ESAs, she decides to rewrite the lease for her building to clarify her policies around emotional support animals. She makes it clear that ESAs are allowed, but specifies that only small dogs and cats are allowed and absolutely no bully breeds, things like, pit bulls, as she considers them unsafe. Can she do this? All right, we can end the poll. We're at about 69% of you saying no, 31% of you saying yes. And the answer is no. So let's talk about it. So restrictions on breed or weight or size of ESAs are prohibited, including those imposed by insurance companies, and we'll talk about that. Because a determination about whether an emotional support animal is a direct threat to health or safety, it should be done on a case-by-case basis. So you can't use stereotypes. There's a lot of stereotypes out there about like pit bulls and German shepherds and that they're mean and unsafe, which are very, very much not true. Every animal is different, and every specific animal should be evaluated on a case-by-case basis. That means, even, if you have written into your lease, these types of dogs are not allowed, that is not okay. When it comes to an emotional support animal, even if that landlord's insurance company, their homeowner's insurance says, you can't have this specific breed, they are also subject to these laws. That means insurance companies They also have to allow reasonable accommodations or changes to their policies. So it's not an excuse to say, hey, I'm just not going to rent to you because you have a German Shepherd. Um, but if you are evaluating, somebody has an ESA and then a month after they move in, their dog is growling at people and is aggressive, that probably would be grounds for you to say, hey, this is not going to work because your specific dog is not safe. And, as a housing partner, you would have to get together with the tenant and try and come up with a solution to that. But, it could form the basis of saying, no, I'm not allowing this dog. Maybe you could get a different animal that would not be unsafe, but we're not allowing this one. But it's a case by case basis. And I've talked about this already a bit, but housing providers can have reasonable rules to as to how animals are cared for and kept under certain control when they're in an apartment complex. So, for example, things around waste disposal, animal behavior, things like excessive barking and noise, those rules can be implemented as long as they're not being done in a harassing way, in a way that singles out somebody with a disability. Um, Also, housing providers can't impose different rules for ESAs than they do for other animals. So say for example, you are moving into an apartment building and you have an ESA that's a 50-pound dog, and the apartment building has a cap at the size of dogs at 25 pounds. So you ask for an exception to that policy, and they say, yeah, we'll give you that exception, but you know, all the other dogs are allowed in this specific common area to run around, but your dog is too big, so no, can't do it. That would be unlawful because you're putting additional rules on an emotional support animal. So, and there is a law in California, I'm not going to spend too much time with this, where things got a little confusing for people around having dogs that are ESAs, and people started to think that it had to be from a licensed medical professional in order to have a dog that's an ESA, but this law does not apply to the protections. So it does not impact things. It doesn't mean that you have to have a doctor evaluate your need for an ESA in California. So just mentioning that. All right. So now we are going to move to service dogs. So this is Luis. Luis has epilepsy, and he has a service dog that alerts him when he's about to have a seizure. He goes to see an apartment, and the landlord says that he has to request a reasonable accommodation in order for him to have a service dog. Is Luis required to request a reasonable accommodation? I think we let, oh, there we go.
Yes, I apologize to those who already answered the previous poll. That was the wrong question, so please re-answer this one. Thank you.
Okay, we can go ahead and end the poll. We're at almost a complete split of 50-50. And the answer is no. So let's talk about it. So here, Luis's dog is not an emotional support animal. It's a service animal because it's a dog a dog or an animal that is specifically trained to alert somebody or to do a specific task for a person with a disability. And because of this, the laws are different. So let's talk about when you have a service animal. So service animals are animals that are trained to perform specific tasks to assist individuals with disabilities, including people with mental health disabilities. And while service animals don't need to be professionally trained or certified, they are trained to do some type of activity to allow access to a person with a disability. So we're a good example are guide dogs for the blind or animals that sense seizures, like in our example. They're not considered to be emotional support animals, and they're not considered to be pets. They're animals that are specifically trained to do something to assist someone with a disability. And in California and under federal law, we have laws that require businesses, including housing providers, to give full and equal access to people who use service animals. I will say, under the federal law, the law defines a service animal as a dog only. Any dog that is individually trained to do work or perform tasks for a person with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. So just keep that in mind. So if somebody has a service animal and they're asking for access, they're asking to move into an apartment with their service dog. They're going into a coffee shop, um, and they have a dog that can sense when they're having a seizure, or maybe the person's diabetic and the dog is able to tell when somebody's, I think it's hypoglycemic. Can businesses do anything, or they just have to take someone's word for it? For the most part, businesses do have to take someone's word for it, but they can ask two questions. They can ask, one, is this animal required because of a disability? And two, what is the task they've been trained to perform? That is it. If it's really obvious that an animal is a service animal, if you're somebody with a guide dog, and you're blind and it's obvious that that's what that dog is, they shouldn't be asking those questions. Things like, if a dog is helping to pull a wheelchair, it's just very obvious they shouldn't be asking. But, if they want to inquire, these are the only two things that they're allowed to ask. So this is Luis again. Luis provides the landlord with information about service animals. The landlord asks the permissible questions, and Luis explains that the dog alerts him when he's having a seizure. The landlord replies, I've never heard of that. Can you show me so I know you're not lying? Can the landlord ask Luis to do this? All right, I'm going to go ahead and end the poll. A vast majority of you said no, and you are right. So you cannot ask people with a disability anything other than those two questions. You can't ask them to demonstrate the task. And honestly, it would be very difficult to do so because you'd have to be about to have a seizure. And how could you predict that? That's the whole point of having the dog. So no, they can't ask for the demonstration. So with that, we're going to go ahead and end. I know we have a ton of questions, but first I just wanted to point your attention to some of our resources. This is a QR code that brings you to a lot of our resources. On our website, we actually have some new handouts. We have one specific to ESAs, but we also have some specific to reasonable accommodations and modifications. Also, CRD, we do free webinars 3 times a month on different topics involving discrimination. We do a general one on disability discrimination every other month, for example, and just housing discrimination. We do employment discrimination. We do a bunch of other things as well. And we have some of these trainings on demand on our YouTube. And yeah, I'm happy to answer questions.
Amazing. Thank you so very much, Kara. That was a fantastic presentation. And thank you all who participated in the polls. I loved seeing your engagement and seeing your responses. I think we all learned a lot today. So you were right, Kara. We do have a lot of questions to get through. And folks, please feel free to continue dropping questions in the chat, and we will get through as many as we possibly can. So I'm going to go ahead and start from some questions that we had at the top of the presentation. A great question from both Samantha and John. They asked essentially, are case managers, or rather, as case managers, can they write their own emotional support letters in support of their clients' reasonable accommodation requests?
If you're in a position to know why, if your client has a disability related need for an emotional support animal, and oftentimes you might be because you're checking in with somebody pretty regularly, they're talking to you, you're helping them troubleshoot things, then yes, absolutely. Social workers or case managers are often in a really good position to provide this type of documentation.
That's great. And then a follow-up question that I think we will know the answer to, or many of us can guess, but just to clarify, Brita asked, can an MSW or a Master of Social Work write an ESA letter for their client, or do you have to be an LCSW or a licensed clinical social worker in order to be able to provide that letter?
Yeah, the answer is no. It's any third party that's in that position.
Fantastic. Question from Julie. This has to do with clients who are temporarily sheltered in hotels, likely working with an advocate. Julie is wondering if hotels are required to abide by fair housing laws, and what do they do as an advocate if a hotel provider does not believe an emotional support animal is an emotional support animal and they want to charge a pet deposit? That's an interesting question.
Yeah. So yes, hotels, temporary accommodations, things like Airbnb, they all have to abide. Also shelters, they have to abide by fair housing laws and allow emotional support animals. If they're asking for, things that they're not supposed to be asking for an ESA, like a pet deposit, I think realistically, people can file complaints with us if they're in California, but I think what can be the most helpful in those situations is showing people handouts and stuff. We have a bunch of stuff on our website that answers some of those questions, and like, for example, our handout on reasonable accommodations will say things like, here's who has to follow them, and like, you can't charge a pet deposit, and, they could ask for documentation of the need if it's not obvious, but yeah, they have to follow it just like everyone else. But yeah, those can be sticky. You could also talk to somebody in legal aid or an attorney and have them write a letter for you. If you're a service provider from like a larger nonprofit, it might be helpful for you to have, some type of materials or way to document that need. But yeah, we actually did a case a couple years ago in California where a shelter wasn't allowing of emotional support animals, and they ended up having to pay a settlement and do a bunch of things because we said no, you can't do that. You have to let people have it. And I think a lot of people who work with people who are chronically homeless know that if you don't allow emotional support animals, people might not access the care that they need because they want to stay with their animals. So
Absolutely. Thank you, Kara.
yeah.
Um, I want to circle back to something that I think is very important that you just said, because I know a lot of folks on the call with us today are people that work at shelters, either domestic violence shelters, transitional housing facilities, or homeless shelters. So I want to follow up with what Kara just said, that those shelter providers are also required to follow fair housing laws. And then ask a question from Katie, which was, what are emergency homeless shelters allowed to do and what are they not allowed to do regarding emotional support animals, particularly when that shelter is set up in a way where we have 40 plus people all living in one room?
I mean, I think that for the most part, you are required to follow fair housing law, but you can have specific rules or things to when things are not feasible. If it's completely infeasible to allow that, then you may be in a position to deny a request for accommodation, but you still need to work with that person to try and come up with a solution, or just figuring out, there's so many different possibilities or solutions for things, and you just really your default shouldn't be this is impossible. It should be okay, what can we work out? Um, but yeah, I think the law does contemplate that not every situation is going to be ideal, but the reason that it's written in the way where things are flexible and you're supposed to be working towards a solution is for things like this, because we know there's like a push and pull for both.
Fantastic. Thank you. Question from Anita. This is a great question. Anita says, what is an example of a disability where someone would need more than one emotional support animal? Any
I
thoughts?
mean, I think you could think of many things. I mean, I've worked with a lot of people with PTSD, and they have had a dog that kind of helps them maintain its structure. They get out of the house once or twice a day to take walks with their dog, and they have to get up to let their dog out. And then maybe they have a cat that provides emotional support when they're stressed out or depressed or anxious. They have two different functions and needs, and maybe both of them provide different types of support. So yeah, everybody's situation is so different. So
Fantastic. Question from Helen. Helen says, I'm struggling with the definition of disability. Some clinicians and attorneys seem to look at disability very specifically, as the VA or Social Security does. Can you share more about the definition of disability for today's presentation?
sure. So it's important to note that under federal law, the definition of disability is different than under California law. So under federal law, a disability is something that substantially limits your ability to perform a major life activity. And what that is major life activities are the things you need to do to go about your day-to-day life, to care for yourself, to, things, everything from, walking, standing, eating, to bathing yourself, to working, to communicating with other people, to, how your body functions. And under federal law, it has to be a condition that substantially limits one of those activities. So, maybe you have a mental health disability that makes it so it's almost impossible for you to get out of bed. That would probably substantially limit, your ability to care for yourself in that way. In California, the law is a little more broad. It just has to limit in some way. So, for example, if you have a disability where you're able to get out of bed, but it might take you a little longer, or, it might make it more difficult to perform that life activity. Under California law, you would probably still be considered to be disabled. But, even the federal law, the definition is pretty broad. I mean, major life activities can be so many different things. And, if something is getting in the way of you, if a condition or something is getting in the way of you being able to do those things, you would be considered to be disabled. It doesn't have to be something that's so disabling that you can't do anything. It just has to impact some parts of your life that you need to care for yourself, or something that your body is having a hard time doing, like maybe an impact to your digestive system, for example. But the law is a lot broader than you think it is, if that makes sense.
Fantastic. Thank you.
Yeah.
Um, this is a question that was submitted in our registration form that I think is worth circling back to because it has to do with insurance. So, this question was, our shelter does not have liability insurance that covers animals, emotional support animals, and service animals. Are we still legally required to allow these animals access to our shelter if we don't have liability coverage for them?
Yes. If you have liability coverage for people and it doesn't, or if you have insurance and it doesn't include that, and your insurance provider says, this is only for people, they both have to allow an exception. And if you feel like it's necessary, you would need to make an exception and cover that. I mean, having liability insurance is not necessary to run a shelter. I mean, it depends on where you live and the circumstances, and I'm not going to get into that. But, at the same time, I mean, if there's a scenario where it really would be like completely impossible, maybe, you would be able to say that it's going to be, or maybe the cost of the insurance is so expensive that it's going to make it hard for you guys to make that payment. Then you could say, hey, this is an undue financial burden, but you'd have to still work with that person to try and come up with a solution. Maybe like a temporary place for them to have their animal, maybe trying to relocate them somewhere else. You still need to work with that person. But again, the law kind of gets that every scenario is not ideal. And, but you can't just be like, hey, this is too expensive or not possible, and that's it.
Um, are shelters legally required to allow service animals in shared spaces like dining areas, kitchens, or shared living rooms? And then same question, but for ESAs.
Yes. Yes, for both. I think service animals, it's a little easier because they're often like they have to be with that person at all times. For ESAs, I think, if you could have maybe more reasonable rules, if there's like a feasibility issue where the person can still get the benefit from the ESA, but maybe the dog doesn't go into the dining room with them and there's a space for them to be when that's happening, that could be reasonable. But it really depends on the case by case basis. If it's, a dog, an animal where with an ESA where having it kind of in close quarters with you at all times is necessary, then maybe not. But yeah, it really depends. With service animals, it's a little more cut and dry because the law just says they should have equal access. So,
Fantastic. Thanks. Um, Lots of questions. We've got about 5 minutes left, folks. I don't know that we're going to be able to get to every question today, but we will sure do our best to answer as many as possible. Question from Julie. This has to do with ESAs on airlines, which I know has been a hot topic in the last, decade or so, and there have been some changes. So Julie is wondering about airlines that say that the only ESAs that they allow are dogs and cats. Is that violating the law?
so ESAs are specific to housing law, which means it's a term of art and something that's contemplated under the law as far as accessing housing. Airlines are under some different regulations. They are businesses, so they are subject to some laws. But usually, ESAs are not something that is the law really requires airlines to allow. Service animals is different. Service animals, again, people are supposed to have full and equal access. You have a guide dog for the blind, you have an animal that can sense a seizure. Those animals should be given access. Other types of animals, the law that I'm talking about, this is really outside of that scope. And, ESAs to my knowledge, are really specific to housing law, if that makes sense. And so, like, for example, if you go on one of those websites and get a vest that says ESA and you try and go on an airline, like, they probably would be well within the rights to say no, because it's not actually like a legal requirement for them to allow that. If you go on an airline and you say this is a service animal and they ask you those two questions, then that would be different. So I hope that's helpful.
Yeah, thank you. Thank you, Kara. And it sounds like, yes, fair housing law only applies to housing. And the law that applies to, I think, airlines is the Air Carrier Access Act, which has changed their, I think, position on emotional support animals.
All
Um,
right, that's good to know. I don't, yeah, it's outside of my area of expertise, so good
yeah.
to know.
Let's see here. What other questions do we have? Um, just circling back to what you spoke about regarding breed restrictions, Belle is wanting to confirm that service animals and emotional support animals cannot be restricted from spaces based on their breed alone. So even if an apartment complex says we don't allow pit bulls here, that is not applicable to either service animals or emotional support animals. Is that correct?
That is correct. So your analysis, if you're saying an animal is not safe, you have to be looking at that specific animal. Every animal is different. And, a lot of those stereotypes aren't even legitimate. So, yeah, it's case by case basis. You might not want an emotional support snake in your apartment building, but that doesn't mean you're not going to be able to say no, if that makes sense. Yeah.
Absolutely. Question from Stephanie. She's wondering if an ESA's status ever expires.
I mean, I'm not totally sure what the question is. Like, I think maybe what you're getting at is like, can housing providers, ask you to provide ongoing documentation? I would say, I mean, generally, I would say no, um, unless, it's somebody had like a temporary disability, maybe, but even with those types of disabilities, usually it's not going to be an ESA. So for the most part, no. I guess if a housing provider has reason to believe that something has changed, but at the same time, people have a right to their confidentiality. So I would err on the side of saying, you know, once the person's provided that documentation, let it be.
Fantastic. We are at the hour, folks, so I think we're gonna have time for just one more question. And I know there are quite a few here. So let me scroll up really quickly, see if there's any new ones. Um, see. Okay. So if you are someone that is in the position of writing an ESA letter to a client or patient, is there any specific language or format that should be used when writing these letters?
As a government entity, I can't give you that information. What I would say is the law says that you only need to provide enough documentation to verify the need. And there's a lot of resources online as to specific language. And another thing I would say is we at CRD are almost about to launch a reasonable accommodations letter request generator. And it helps people with disabilities make that request. And there is some approved language in there that folks might want to take a look at. But I would say just generally, I mean, you could, just repeat some of the stuff from the resources I've given you today. Um, but I think telling you what to put in the letter, I think kind of crosses the line, no legal advice. But, you don't have to say, I mean, the important thing to say is that you don't have to disclose anything more than what is necessary to confirm the need. You don't have to say this person has schizophrenia because oftentimes people don't want folks to know their business and their confidential health information, and that's reasonable. Yeah.
Fantastic. Well, we are out of time for today, everyone. Again, just thank you so much to everyone who joined
Yeah.
for your engagement, for all of your incredible questions.
You.
We weren't able to get to them all, but we really thank you for joining us.
Yeah.
Really thank you, Kara, for joining us today. This was a fantastic one.
Great. And yeah, I'm happy to come back. I love talking about this stuff. It's an area I'm very passionate about. So yeah, happy to do it. Thanks so much, everybody.
Yeah, and many, many thank yous are coming through the chat in case you
Great.
see
Thank
them.
you so much, everybody. Yeah. Go
Wonderful.
check out our resources. Take care.
Thanks, everyone. Have a great rest of your day.
Bye.